Hi, my name's Sumaira and today I'm going to be doing a tutorial on negligence and the duty of care in tort law. So first we're going to try and get an understanding of what a tort is, and then we're going to understand what negligence is and what makes up negligence. How do you actually decide if someone has behaved negligently? So the first thing to note, which is kind of just to introduce what torts are, tort means wrong in French, and it is a civil wrong as opposed to a criminal wrong. And because it's civil, it's often punishable by payment of damages as opposed to a prison sentence, for example. And the most common tort is negligence, and that's why we're going to focus on negligence today, and specifically the first step in establishing whether someone has behaved negligently, which is establishing a duty of care. Okay, so negligence is made up of 4 elements, and the first of these is establishing a duty of care. Then this is a duty of care between the claimant and the defendant. So there's 2 specific people in the scenario. And then there must be a breach of this duty of care. Anyone can owe a duty of care. It doesn't necessarily mean they've breached this duty of care. Then these 2 factors, which are summarized as causation, which we're not going to focus on today, are important for deciding whether the damage specifically has been caused by the defendant's breach of their duty of care. So it's kind of step by step in that sense. One important thing to note is that negligence is based in the common law, and the common law means it's not an act of parliament that's been passed, and therefore it's not a statute. You can't just go on the government website and find the step by step for the duty of care in negligence, for example. So it's been developed incrementally over time, and it's somewhat piecemeal, which is why we have to go through various cases to see what we mean today when we say what the duty of care is. But we're going to focus on how to establish a duty of care first. Okay, so duty of care comes from, let me just center that 1 second. Yeah, so the duty of care has its origins in the case of Donahue and Stevenson. And I say its origins because this is a case that really widened what we thought of as the duty of care. And in this case, Lord Atkin created what he called the neighbour principle. The quick facts of this case are that one friend buys 2 ginger beers. One of them has her friend's beer has a snail decomposing in it, which makes her ill, and she seeks to sue the manufacturer. But she doesn't want to sue the manufacturer on the basis of a contract because she doesn't have a contract with the manufacturer. She did not buy the beer herself. However, she seeks to sue on the basis of negligence, and that's how the duty of care starts to emerge here. Now, Lord Atkin's neighbour principle seems to be that whether A being the defendant, B being the claimant, which can be used interchangeably, for example D and C, which you'll see later on, whether A should have had B in their reasonable contemplation. And without this, there can be no negligence. A duty of care has to be established. Now that sounds a bit convoluted, so if we wanted to say what this meant in modern terms, we ask, was the damage to someone in the claimant's position a reasonably foreseeable consequence of the defendant's actions? And it's this idea of reasonable foreseeability that's really key. So let's just highlight that. So were the actions reasonably foreseeable? Was there a foreseeability of harm of that defendant to that claimant? And remember, the duty of care is a relative concept. It's not that we owe a duty of care to everyone in the world. That would be wholly unreasonable and unworkable. So this is very important to know. Okay, so now we've looked at the basic origins of the duty of care. We can look at how the court started to develop this duty of care and refine it over time. So now, we don't just hear of this reasonable foreseeability which Donahue and Stevenson introduced, we start to hear of this word proximity. And proximity is kind of an elusive term. We're not really sure what specifically it means when we first hear it. In Anne's and Merton, Lord Wilberforce starts to bring it in. He adds to the idea of reasonable foreseeability, as you'll see here, and asks the question, is the relationship between the defendant and claimant one of sufficient proximity so that the damage to the claimant, is reasonably foreseeable. So is this damage reasonably foreseeable? But then Lord Wilberforce adds a second question. Are there any considerations which call for reducing the scope of damage or liability? In modern terms, we would think of this as a policy consideration, something that means that, okay, maybe on a strict legal sense there would be a duty of care, but should we mitigate this for any reason? But this sounds quite confusing for now, and the courts made this much simpler in Kapara and Dickman, which is the case that really lays out the 3 stages for establishing a duty of care now. So, the first is foreseeability of damage. We got this from Donoghue and Stevenson. It's an objective test, not a subjective test. And by objective, we mean it's based on facts. It will be the position of a reasonable man as opposed to that specific defendant. Because if we just simply ask that specific defendant if they thought that harm was reasonably foreseeable, they're not likely to give us a good answer, are they? So, remember, this also is in relation to the event and the time of that act and omission for those specific parties. So it's very tailored. It's not just very broad. And is that damage foreseeable in any circumstance? It has to be in that circumstance, in that time, for those parties with those actions or lack of actions. The second thing, which is what Lord Wilberforce started to talk about in Anne's and Merton, is a relationship or proximity between the parties. We can generally define proximity as a degree of connection between the parties. So is there something linking them that would mean there is a relationship that could give a rise to a duty of care? And Boyhill and Young is a very good example of this. So a motorcyclist had a crash. However, a woman was pregnant and she was walking in the street, not close to the accident, but she saw the accident, was traumatized and miscarried as a consequence. She tried to sue the motorcyclist for this. However, it was not foreseeable to the motorcyclist that she would suffer harm from across the road. They weren't in a sufficiently proximate relationship. So it's not that it would be a different case if she was, for example, hit by the motorcyclist. They would be in a foreseeable proximate relationship, but it's not the case in terms of her just seeing it from across the road. Finally, we start to see this introduction of policy considerations. Is it fair, just, and reasonable for the courts to impose this duty of care on the parties? Now, this is often talked about in terms of, is it proportionate, and we'll hear the term public policy a lot. So these are just external factors which aren't really key to the legal case, but may mean that we don't impose a duty of care for one reason or another. Or we do impose a duty of care for that reason as a consequence. For example, in Nettleship and Weston, a learner driver, whilst not at fault for the crash in the sense of fault because they were learning to drive, they had a duty of care placed on them because of the circumstance they were in. Learner drivers have insurance, so the costs fall on them, even though you can't really say a learner driver is at fault for crashing. The risk has to fall on someone, and it's about balancing out proportionality, seeing what's fair. And so the courts will make this assessment to establish whether a duty of care can be met. If you can answer all of these, you can establish whether there is a duty of care as a consequence. Kapara and Dickman also noted that the categories of duty of care should develop incrementally and by analogy to those categories that exist at present. They shouldn't just be made up or expansively introduced whole categories. So just to summarize, a duty of care is essential. There should always be considered in negligence cases unless there's a good reason otherwise. And Kapara and Dickman summarizes this as foreseeability of harm, approximate relationship, and if it's fair, just, and reasonable to impose this duty of care. If you can answer all of those and all of these are found to be the case, then you can establish a duty of care and move on to establishing whether this duty of care can be breached. It acts as a limit. It means that we won't always all owe duties of care. And in terms of omissions, it's just key to note that generally, criminally and civilly, you don't have a liability for omissions, but there are always exceptions. So that's just a summary of the duty of care and negligence, and I hope it was informative.